meeting to order. Welcome to meeting number 68 of the House of Commons Standing Committee on Citizenship and Immigration. Just a reminder to all the members that we will be meeting for 3 hours today. So the meeting will continue for 3 hours. We'll try to have a little break after like halfway through. So Bill S-245, an act to amend the Citizenship Act, granting citizenship to certain Canadians. Today, pursuant to the order of reference of Wednesday, November 16, 2022, the committee will resume consideration of Bill S-245, an act to amend the Citizenship Act, granting citizenship to certain Canadians. We are continuing our clause-by-clause study of the bill. When we left off, we were debating on the amendment moved from the floor by Ms. Kwan, which has now new version of NDP 8. So we are at NDP 8, new NDP 8. The floor is open for debate. Thank you.
Thank you, Madam Chair. I think I had the floor when votes happened on Monday, so I was about to begin my line of questioning. The first question I wanted to ask, and I've had some time to compare the two versions. I'm not sure which version I prefer, whether I think some sub-amendments might be necessary to bring it back to the previous one. But can maybe the department officials explain what is actually the difference between the two, the original NDP 8 and this new version of NDP 8? I just want to understand the differences and how adopted children and adopted parents would be affected.
Am I on? Thank you, Madam Chair. As was stated in the previous hearing, one of the important differences is that this version does not include grandparents for the purposes of the connection test, and so the connection test is available solely for parents. And I'll just turn to my Department of Justice colleague in case there is anything else that she may wish to mention.
Thank you for the question, Madam Chair. My understanding is also just that the amendment includes a number of cross-references to previous amendments that were already passed. So it's sort of a coordinating motion. Thank you.
So in the latter clauses in the, I think it's subsection, I'm going to name it wrong, but it's at the very back, paragraph 5.1, 4B of the Act is replaced by the following. There's a paragraph here, and at the very end, it makes a reference. I'll just read the last part of it. And at the time of their adoption, comma, neither of the adoptive parents was a citizen who had a substantial connection with Canada. This substantial connection reference, is it a reference then to the substantial connection test that this committee has amended, or is it a different substantial connection test?
No, that's correct, Madam Chair. It's the connection test that this committee has voted on.
Okay. Is it possible to have two different substantial connection tests for different parts of the legislation? One that would apply only for adoptive parents, like if we were to sub-amend this to have a different one, is it something that's possible to have within the bill, and a different part of the bill has a different substantive connection test that you could apply? And I'd also like to hear if there's a judicial opinion on that. Would that also stand up in court if it was amended to have two different tests for two different situations where a person is either trying to regain or retain their citizenship?
Madam Chair, it's open to Parliament to legislate, as has been mentioned before. This amendment is seeking to make the connection test available for international adoptees where there's a Canadian parent, with the same connection test that was previously voted on by the committee that would apply to natural-born children. And so, as discussed previously, it's looking to minimize those distinctions between the natural-born and the adopted children of a Canadian with respect to the second generation born abroad in both cases. So while it's possible, it's not necessarily desirable for the purposes of of equity with regard to this proposed amendment. Thank you.
Could I hear maybe from the Justice Canada official, if the committee were to amend it, or in the future, if the government or any member through a private members were to amend the original substantial connection test and say exclude adoptive children, but apply, because I had tried to do a sub-amendment at the time that would have made it a consecutive 1,095 days. We had considered maybe doing things like, applying a test to see whether a person would, if they have a criminal record, that would be grounds for not being able to show or demonstrate a substantial connection. So I'm just wondering if this stays as it is, applies differently to adoptive parents, adoptive children, which I actually kind of like that idea, but differently for others who are trying to regain their citizenship. If it were to go to court, is that likely to stand up in court, or is that likely to cause a lot of problems?
Thank you for the question. I think what I would say is in general, it's open to Parliament, as we've said, to legislate and however it sees fit. So the scheme of the Act, for example, currently has an interpretation section, which are definitions that apply throughout the Act. And that's my recollection, that this specific substantial connection definition is included in that interpretation section, or it will be. And so, if there was an interest or an intention, or the way the Act is structured right now, you have interpretation provisions that apply throughout. I can't think off the top of my head if there's other specific definitions in other pieces, but of course, if there was a term that only applied in one section in the Act, that's specified in that one section. So the scheme of the Act is set up to have a general definition section and then specific provisions in other areas, if that's helpful.
Perhaps other maybe, like you say, you can't recollect an example that would be like a similar situation, but the Supreme Court years ago found that you couldn't prohibit Canadians overseas, abroad, from voting. There used to be a limit. After 5 years, you couldn't vote. They said that to the point of equity that we've heard many times now, a fair point. So the Supreme Court raised the point. It was a violation of constitutional rights of citizens. So I was wondering, in this situation, either through amendments that we do here or through amendments that could be done in report stage, to protect adopted parents, adopted children. I quite like this amendment generally. I'm just trying to get down to, if we were to amend the original substantive connection test, that they not be impacted by anything we make at that particular one. I also understand if this bill passes here, it'll go back to the Senate for review, and potential amendments could be made there on the substantial connection test. I just want to better understand in other court cases and something similar like this in legislation, can you use the same word, but for different sections of the Act have a different interpretation as a direction given to judges who may consider it and the department to handle it? That's what I'm trying to get at.
Yes, Madam Chair. The member is correct that in theory, if not in practice, it's certainly possible to legislate different tests, but that's not what's proposed here because the natural-born children and the adopted children of a Canadian in the second generation and beyond are in a similar situation, and therefore it's proposed under this amendment to have a consistent test with regard to connection. But it is possible. The member is correct.
So on this one, because this would be different in the way we apply the rules, does the department or has the department ever done an assessment to determine the potential impact on existing adoption processes, regulations internationally? Because I think this only impact international adoptions. Correct me if I'm wrong, but only international adoptions with the automatic right to citizenship to adoptive children. That would basically make them equal to, basically the rule applies first generation to them exactly the way it would for those who are naturalized in Canada. So has the department done an assessment in the past? Is one being done while this committee is considering this legislation?
Madam Chair, I'm not aware of any such assessment, but as I think I've stated before, it is desirable to have this mirroring amendment benefiting international adoptees in the second generation, where we have Canadians who are adopting internationally to have the same connection test available. And this will benefit potentially all those who are already first-generation born abroad Canadians and who may either have children abroad themselves in future or choose to adopt internationally. This will be of benefit to them should Parliament choose to pass the bill. Thank you.
So my next question was going to be, are there processes at IRCC for identifying, distinguishing between various adoption systems internationally? And I have a follow-up to that, but that's my first one.
Madam Chair, as I mentioned previously, there are dedicated staff in the department for their purposes of processing citizenship applications, including proof of citizenship applications for international adoptees. And there are criteria, as I mentioned previously, that are standard to be met in these cases around three considerations, and that is ensuring the best interests of the child, that there is a genuine parent-child relationship, as I mentioned, and then there are other legal criteria to be satisfied. The adoption has to be legal in the country where it took place and in line with the laws where the Canadian is living. Thank you.
So my understanding of this amendment and how this would work then, that the adoption is legal in the place it takes place. This would mean, so this would apply equally to Canadian parents adopting from Canada a child internationally, or two Canadians who are parents who are overseas who adopt in another jurisdiction, correct? Like,
yes, that's correct.
There's
yes.
nothing in this legislation. Again, 2009, unforeseen consequences, 2015, we've been through this before, so there is absolutely no difference in these amendments. They'll both be treated equally.
Yes, that's correct.
And so then the question I had is back to the first one, because they're related. So there are processes in place for the Canadian government to determine whether an adoption done overseas in another legal jurisdiction, whether it was done according to those laws in place in that jurisdiction. That's paperwork that needs to be provided to the department during the adoption visa process coming to Canada?
That's correct, yes.
Okay. And in that process, like, and in your experience as well, has there ever been like a court case or an issue where years afterwards there's been a case where the department was found not to have done all the work, there were changes made in processes, or whether that idea or concept has ever been litigated in Canadian courts where there was disagreement between parties on whether the adoption was indeed legal? Has there ever been a case like that?
Madam Chair, just conferring here with my colleague from the Department of Justice, no case comes to mind in recent memory, and by recent memory, I include my own experience from 2009 working in the citizenship policy arm of the department. So I can't say definitively whether there's ever been a case, but not in recent years to my recollection.
Okay, so I have a letter here from and I think all committee members got this sent to us, because as we've been doing these hearings and they've taken a few meetings, there are members of the public who've sent us information. Some of it is very helpful because it comes from Immigration Canada, so it has some content information. This one is from the Executive Director, Denise Mildner, who is from Saskatchewan, the Evermore Centre, and it provides data on the back end. So I just wanted to read into the record and make reference to it, because it kind of feeds into my next question. The voices of many parents have gone unheard. Since 2010, 13,791 children were born abroad adopted by Canadian parents since Bill C-14 and C-37 were passed. So going as far back as 2007. Of these, 63%, or 8,632 children, were adopted through the citizenship stream. Unknowingly, by choosing this route, however, these children do not have the same rights as other Canadians and cannot pass on their citizenship, regardless of which route was chosen. There should not exist any discriminatory laws against an internationally adopted child. Does this amendment fix this particular situation, or does it address a different issue of just passing on and the treatment of the children as Canadian children for the first generation limit?
Madam Chair, from my perspective, this amendment is providing an avenue to address those concerns because, as I understand it, since 2009, some parents of adopted children who have gone the direct grant of citizenship route have been concerned that the first generation limit applies to them as it does to the natural-born children of Canadians who are born abroad. And so, as discussed in this committee, this current amendment would be providing an avenue for those international adoptees who are considered second generation born abroad, in line with the previous amendment that was considered by this committee, which is extending an avenue to the natural born children of a Canadian abroad in the second generation or beyond.
So the letter writer in this case, the executive director, mentions that there's these two streams, the immigration stream and the citizenship stream. Can you just explain the difference between the two? Will this amendment then collapse one of these streams?
Either of the streams. What the benefit that this amendment would have is that the Canadians who are now adopting internationally, where they're selecting the direct grant of citizenship route, that child, as mentioned, is considered the first generation born abroad. And with this amendment, should that child have their own child abroad in the future or choose to adopt internationally, there would be access to a direct grant of citizenship, provided that the parent is meeting the connection test. Thank you.
So, I have numbers here going all the way back to 2010 for both streams in here. So you're saying it's not collapsing them. The numbers show that the number, I guess, of through the adoption streams, this is a header. It says new citizens from citizenship and immigration streams of adoption by citizenship effective year. Goes back to January 1st, 2010 until April 6th, 2023. And it shows that generally adoptions are going down in both streams. About 63% are in the citizenship stream, 37% are immigration stream. So these two streams will still continue to exist. They're both still necessary for adoptive parents?
That's correct. Yes, they'll continue to exist.
And does the department, how can you know, but I'm going to ask anyways, is the expectation that these numbers would then be lifted up if you make these amendments? This would give parents more security of knowing that their children will be treated equally to children who are naturalized in Canada or born in Canada? Is there a potential for that then for international adoptions to be more? It would just encourage more people to take that step to, take it on as an option.
Oh, Madam Chair, from the perspective of the department, international adoptees, since C-14 opening up the direct grant of citizenship to international adoptees, are considered equal to children born abroad to a Canadian, who are Canadians from birth, because any distinctions are minimized to the extent possible. As previously discussed, the benefit of this amendment once again is that it will extend an avenue out for international adoptees in the second generation and beyond. And so that may allay some of the concerns that the member is sharing on the part of the letter writer. Thank you.
I want to just make sure. Thank you, Madam Chair. I just want to correct myself because I said this letter was from Denise Mildner, but Denise Mildner was the person that the letter writer was connecting with. The actual letter writer is Marlene Wall, the Executive Director of Child and Youth Permanency Council of Canada. So I want to just give the appropriate credit to the person who wrote this in, because I do read them, if everybody's wondering. I do read all of it. In here, there is a mention of what they consider the easiest solution, which is elimination of the reference to Section 3 and in parentheses C.1 in the Section 3 in parentheses 3 parentheses A. And then they make a reference to another piece of legislation that I'm unfamiliar with, because C-14s can happen in every parliament. It says there's already Bill C-14 that is specifically for internationally adopted children for direct grant of citizenship, and this should preclude them from being lumped in with other forms of Immigration. Can you explain the C-14 and what parliament this might have been in? Or is she in error?
Yes, Madam Chair. Before C-14 came into effect, a Canadian parent of an international adoptee needed to sponsor that international adoptee through the immigration route, and then apply for a grant of citizenship. And what C-14 did was it removed that requirement to go through the immigration sponsorship route and opened up instead an access to a direct grant of citizenship for an international adoptee, thereby minimizing the distinction with the first generation born abroad a child to a Canadian. Thank you.
Then is it fair to say that this legislation and this amendment, as is right now, would close some of those unforeseen consequences from C-14 back in 2007?
Madam Chair, in 2009, when the first generation limit was brought in, it was not an unforeseen consequence that the first generation limit would apply, and would apply consistently to the natural born children and the adopted children of Canadians abroad in the first generation. But what this amendment is doing is providing an access to citizenship to those adopted abroad in the second generation or beyond, and addressing a concern that that we have been hearing since the first generation limit was imposed in 2009.
Madam Chair, I'm good. I have no more questions on this amendment.
Okay, seeing no further debate, we can go for a vote on new NDP 8. We will be voting on NDP 8. Mr. Clerk, if you can please take the vote.
Mr. Ali. Mr. Ali.
Yes.
Mr. Dhaliwal. Mr. Dhaliwal. Mr. Edikuri.
Mr. Dhaliwal, can you please repeat? You are voting yes?
Yes.
Yes.
Mr. Edikuri.
Yes.
Madame Kayabaga.
Oui.
Madame Lalonde.
Oui.
Mr. Kimich.
Yes.
Mr. McGuire.
Yes.
Mr. Redicott.
Yes.
Ms. Rempel-Garner.
Yes.
Mr. Blanchette-Chonka.
Pour.
Ms. Kwan.
Yes.
Yeas 11, nays 0.
P8 is carried. Mr. Redicott.
Thank you. There we go. Yes, and we have an amendment that we want to move. But before we do that, I just want to return back to the issue that we spoke about, the issue of the students, the Indian students who were given fraudulent acceptance letters and ended up in Canada for a long time and now have recently been given deportation notices. This is something that's very important. And the reason I want to bring this up again today and why this is so important is that these students are actually facing deportation right now, and it's something that we can talk about doing something later, having the minister come in or whatever. But I believe we need to actually look at this now, and we need to deal with it. And I know even today, I believe there's protests going on in Brampton about this. So it's a very relevant issue. And so, Madam Chair, I want to make a motion that pursuant to Standing Order 108(2), the committee conduct a study into news reports that international students admitted into Canada with valid study permits were issued fraudulent college acceptance letters by immigration consultants and are now facing deportation, and that this study undertake at least 3 meetings, that the committee invite the Minister of Immigration, Refugees and Citizenship for 1 meeting, along with his departmental officials to testify, that the committee invite the Minister responsible for the Canada Border Services Agency for 1 meeting, along with his departmental officials to testify, that the committee invite affected international students and representatives from colleges and institutes Canada, and that the committee request that the Canada Border Services Agency temporarily suspend the deportation of affected international students until those selected as witnesses can testify before the committee. I think it's very important that we deal with this issue now, and I think I'd like to hear the committee's will on that, because we on the Conservative side are getting a lot of calls, and we have a lot of people that we know that are impacted by this, and so it's something that I think is important. I think it's something that really needs to be dealt with. As we know, time is running short before the end of the year, and there's only so many things that we can do, and this is something we think could be done relatively quickly, get it done, and get to the bottom of it. Because the real issue is, why did this happen? Why was it allowed to happen? We feel there's probably some processes or things that need to be looked into, fixed, and corrected so that this doesn't happen again. At the end of the day, these students had no idea that this was going on. They weren't trying to game the system in any way. It was fraudulent immigration consultants who actually caused this problem. And so now these students who have been in Canada, they've got their degrees, many of them have been here for years, working, contributing to Canada, doing all these things, are surprised to find out that they can't get their permanent residency, and in fact, they're going to be deported. And so that's why this is something I think is really important to deal with now. So that's why I make this motion, and I think we should deal with this right away, Madam Chair.
Thank you, Mr. Reddycop. I have a speaking list, Ms. Lalonde, and then Mr. Maguire, Ms. Rempel-Garner, and Mr. Kimmich. Ms. Lalonde.
Merci beaucoup, Madame la Présidente.
Thank you very much, Madam Chair.
Would, in principle, agree of the significance and the importance of my colleagues' request, I think, from this side of the House, and I would say for all members of Parliament. We realize how individuals who are fraudulent are and should never be part of the immigration process of those that are victims of this. I also know with confidence that the government is taking this very, very seriously, Madam Chair. But I'm always left to think we have something here that we are discussing that has meaningful impact for many individuals who this particular bill that we are studying, S245, is of the value also. So without undermining, I think, what we collectively from all sides of the House would like to do, and also, Madam Chair, I think in a motion that was actually requested by my esteemed colleagues a few months ago that legislation should set precedents in this particular committee. It was passed unanimously and it was brought by my colleague Conservative. At this time, I would like to adjourn debate.
Ms. Lalonde has moved a motion which is non-debatable, so we will have to go for a vote. Ms. Rempel-Garner?
She did not move to adjourn debate.
She
said she would like to adjourn debate.
No.
And she no longer has the floor, since you had it.
Please, Madam.
No, she said that...
She said she would like to, not that she moved it.
Translate.
Oui. So are you,
So
are
I
you
think she
discriminating
moved
my
it that-
French, my
Yes.
English?
It's just translation services. Like she said that she would move to adjourn the debate. So. We'll go for a vote.
I'll file a privilege.
Mr. Ali. Mr. Dhaliwal.
Support.
Mr. El Khoury. Madame Kayabaga.
Pour.
Madame Lalonde.
Pour.
Mr. Kimmich.
Absolutely against.
Mr. Maguire.
No.
Mr. Reddycop.
I'm against.
Ms. Rempel-Garner.
No.
Mr. Blanchet-Jonca.
Contre.
Ms. Kwan.
For.
Yeas 6, nays 5.
So the debate on the motion is adjourned. Mr. Reddycop?
Thank you, Madam Chair. That's very disappointing. We do have a motion, and actually it's my colleague, Ms. Rempel-Garner. Sorry, an amendment. Sorry. And my colleague, Michelle Rempel-Garner. Yes.
Thank you. I move that Bill S245 be amended by adding before line 18 on page 1 the following new clause. 1.1, Section 5 of the Act is amended by adding the following after subsection 3. Waiver by minister for administrative delays. 3.01, the minister may, in his or her discretion, after having reviewed a person's particular circumstance, waive on compassionate grounds in the case of any person who has waived over 5 years for a response from the Department of Citizenship and Immigration with respect to their application due to administrative delays. Thank you. So my rationale for this amendment is as follows. My understanding is that and I do have it in both official languages here if colleagues got it. Sir, certainly.
Can we suspend so we can have it circulated?
Sure.
Thank you, Madam Chair.
We will suspend the meeting so that Ms. Rempel Garner has moved an amendment. This is being circulated to all the members. So I will suspend the meeting for a few minutes so that everyone can get that in both official languages and look into it, and then we will get back. The meeting is suspended. To order. Hope everyone has seen the amendment moved by Ms. Rempel Garner. So we have the amendment moved by Ms. Rempel Garner on the floor. Ms. Rempel Garner.
Thank you, Chair. So I'd like to state my rationale for this amendment and explain its potential benefits. So we all know how important immigration is to Canada. We also know how important it is to have, when we talk about immigration levels and immigration numbers, that part of the challenge has been in the past that any sort of response from the department can become an impediment to either immigrating to the country or obtaining citizenship. And many of us around this table all have constituents where we've had cases that this motion exactly speaks to, where their case is just lost in limbo in a massive backlog that is in the system. I don't have the current stat as of today, but I believe that I think there's around 2 million cases. I'm looking at my colleagues in the inventory, and I think it's what I'm thinking here is that instead of, right now we don't really have any recourse as parliamentarians, or people that are in the system really don't have any recourse for when the Department of Immigration doesn't meet its service standards. And that is very detrimental to mental health, to Canada's reputation in terms of attracting and retaining talent. And what I'm thinking is that if this was embedded in the Act, that all of a sudden it now becomes the department becomes motivated to look at these cases that are wasting in the inventory, that haven't met service standards, because they will be inundated with requests for for review based on this component. And I think it would also motivate the department to not let things get to this point. I want to just state why I think it's so important that we do this. I have had numerous cases where, particularly family reunification, people have not received responses from the department, and the tools that I have as a member of parliament to respond to them are very limited. Frankly, what we hear from the department quite often is, well, sorry, we can't do anything. We're working on the backlog, don't worry. But it doesn't seem like there's political impetus right now from the minister to push down into the department, and I know we have colleagues here from the department, but I don't really feel like there's any sort of managerial motivation to move faster, to do things better. Like we're just still moving at this pace, and we are actually talking about non-compassionate actions at this point. That's really what it boils down to. I personally know what it's like to be separated from a spouse across a border. I personally, it wasn't due to the department's backlog, but I was separated from my spouse during the pandemic for a period of nearly a year. And that was very difficult on us. But we made it. God bless you, Jeff. And I would just, Chair, like to put on the record, if my husband is watching, to tell him to not get on the tractor today. He had abdominal surgery, and I feel like this is a very good opportunity for me to scold him in public. But it is very difficult, particularly in cases of family reunification, when there is not an end date in sight. And the department has an onus to consider compassionate grounds when they're responding to people they're sitting in the inventory. What we would be doing, colleagues, as parliamentarians, is essentially enforcing a service standard upon the department, but also give people who really feel like they have no hope a little bit of hope. And also, frankly, like in the minister's defense, also give the minister a tool where, and I know I've been in cabinet before, and I worked with some very talented public servants that I still very much appreciate to this day, but I also know what it's like to be told, no, sorry, we can't do that, instead of looking for solutions. As a minister, it takes time where you have to convince cabinet colleagues, people in your department, the PMO, the PCO, to say, you know what, telling me it's not good enough or I can't do that is not enough. And that process does take time and a lot of political will to end up pushing against your bureaucrats and saying, no, we've got to do better. What this would do is actually give the minister a tool to say, while they are doing that, while they are pushing their department to do better or perhaps clean up the mess of a previous minister, as happens from time to time, it gives them a tool for some of the worst cases to actually have some hope. The other thing that it would do is many of these cases, I've had, as an opposition member, the only tool that you have to try and get a response from the department is taking it to the media or, raising the issue day after day in the House of Commons, knowing that the department doesn't care if you raise it in the House of Commons. They don't care. It doesn't matter to them. They're just going to continue on their merry way. I think that instead of having to do that, it would give people like all of us sitting around the table a tool as well to communicate with our constituents and saying, listen, this seems really bad. We've done everything that we can to try and figure out what's going on in the department. Now we're going to appeal to the minister on your behalf. That's better than me just saying, okay, well, I'm going to try and make, a big case out of this in the House of Commons or go to the media, and my next point will be, that is a better way because sometimes as people sitting around the table, we don't actually know what the details are of these cases. We, as parliamentarians, we have to also rely on the independent third-party arm's length review of an immigration process because it shouldn't be politicized. We just had a, entire series, and I have to give all colleagues in this room credit, a series of very troubling meetings where we essentially heard that a member of the other place was issuing travel documentation out of her office without the oversight. And I have to give my colleague, Ms. Kayabaga, who I think both of us were looking at each other incredulously as the details of this were coming out, because we're like, how did this happen? We don't, as parliamentarians, our job is not to actually make determinations, as I think our colleague from the other place did ourselves. We have to rely on arm's length processes from within the department. So what this amendment would do, if it was in the Act, was allow us to say, look, we can now appeal to the minister on your behalf, but we're going to let the minister and the department sort this out for you. And that is a better route than taking things to the media or, let's say, issuing travel documentation off of the corner of one's desk. This is a common sense tool. And frankly, the other point is, colleagues, the reality is there's a massive backlog of responses within the immigration department. I appreciate, and I know that the department has a new deputy minister who seems very dynamic and understands the gravity of the situation, but I also appreciate that she's probably facing a lot of inertia in her department. So it's incumbent upon us as parliamentarians to look and think outside the box beyond just more consultants and we won't even talk about the McKinsey contract. I have no idea what happened there. That was a bit of a surprise, but there was a lot of money spent by a consultant that I'm not sure really resulted in anything. So as parliamentarians, we should be looking out of the box at low cost, easy ways to have extra tools to expedite cases that clearly need expedition, if you will, or need to be expedited. I'm using the verb tense wrong. When the department is saying, well, we're implementing all these other systems, because at the end of the day, this is about compassion. And I hate being in a situation where I have to say to a constituent, I don't know what I can do next outside of taking this to the media and making this a political issue. I would like to occasionally not make things all about politics, but actually work collaboratively with the minister or whatnot to just say, look, I appeal to your heart, I appeal to your sense of justice. Your department has been sitting on this for 5 years. I don't understand why. I can't get a response. Can you look at this from a compassionate means perspective? My understanding is now we are looking at amendments to the broader scope of the Citizenship Act. I would hope, this is not a partisan amendment in any way, shape, or form. It doesn't benefit, it doesn't take a partisan ideological perspective on immigration. It's very much a process-oriented amendment. It says, if the department is running so far behind in their inventory, in spite of staffing up and spending millions of dollars on consulting contracts, but I digress, that there is a tool that the minister can use to address situations where families are separated, people are facing extreme persecution. We're on the eve of Pride Week. Our Pride Month starts tomorrow. I think all of us here understand the gravity of, let's say, members of the LGBTQ plus community who are in Uganda. There are people sometimes who need to come to this country and get safe haven. And when it really bothers me and it cuts my soul when I hear from the department, I don't know where this case is, or there's nothing more we can do right now. I'd like to say, well, there is something you can do, and it's this, and it's in the Act, and it's hope. And I don't think that's a partisan thing. I think that that is something that all of us here could agree, oh, this is a great process amendment. It's not ideological. It doesn't add more burden. It just gives the minister a tool to say yes or no, but a tool that thinks around the box, thinks around pedantry, and is nimble. It speaks to nimbleness and the ability to have nimbleness in government. I will point out technically, I understand that, I've just made this argument that parliamentarians can't and shouldn't. I want to be very clear on that. Parliamentarians should never be making decisions on immigration files. That's not our job. But the minister is duly constituted to do that. And what this would do is explicitly give him a tool where his department is not responding to a case to allow him to do so. I've been waiting for years to move an amendment like this. I think this is an easy, no-brainer amendment. I also think that I can't see a lot of resources having to be expended to do this. I think we would have a lot of support from the immigration lawyer community, the larger civil society groups. I would just ask my colleagues to support this. This is, to me, a no-brainer. And my understanding is, given the instructions in the motion that was passed in the House to this committee, that this is easily in scope. And I ask my colleagues to support it. Thank you.
Thank you, Ms. Rempel-Gardner. We have a speaking list. Next is Ms. Kaya Baga.
Thank you, Madam Chair. And I do appreciate my colleague's comments and her intent to be compassionate. And I think that's what this whole entire bill is doing, is to be compassionate. And we do have an expectation from the people who are watching. They're waiting for us to actually get going, to pass these amendments so that we can be compassionate in this approach of making sure that we respond to this need. But I do have some questions for my colleague around this amendment. What does it have to do with lost Canadians? And number two, does this amendment impact anything outside of citizenship applications? My understanding on this is that the amendment to Citizenship Act could only apply to citizenship applications and not PR or temporary visas. So what is the relation? And if she could respond in, with the relevance of what we're talking about here today, so that we can actually be compassionate by moving these amendments fast enough, because people who have been waiting for years, and talking about things that are not relevant to stretch time is, I have lots of respect for my colleague, but it's inappropriate, and we are actually putting more burden on these people. So.
Thank you, Ms. Kaya Baga. Next I have is Mr. Kamich. and then Mr. Dhaliwal.
Terrific. Thank you, Madam Chair. So, yeah, I can answer some of those questions. There's a 294,000 citizenship application backlog, and I think there must be in that 294,000 group of people some people who would benefit from the minister being able to look at their files personally and be able, on compassionate grounds, to waive the requirement. I would then hope that they do the citizenship ceremony in person. I think they should all be doing all of them in person, and virtual ceremonies should only be done in cases where a person's health is failing. And who knows, maybe in those situations, again, the minister could go and provide a waiver. I generally, as a general rule, I don't like giving the executive even more discretionary powers. But on this side, like my colleague said, most of our constituency offices are inundated with individual case files. It's about 80 to 90% of the work that our constituency offices are now doing. I've heard of individual members of parliament now having more than one case file manager, which was not the case 8 years ago, before this government took charge of the immigration system. One case file manager for EI, CPP, and immigration case files, usually enough. That person usually handled 80 to 90% of them. But I know that there's 294,000 citizenship applications which are in the system right now. Overall, like my colleague had said, there are 2 million applications. 1.1 million the department claims are within their standard processing time. But since the department sets its own processing time, it can be whatever it wants to be for any one of them. 800,000 of them are over the 80%. The department then claims is considered, backlogged applications. I think this could apply to anything beyond just the simple citizenship applications. I think this could, in the way that it's written, apply to other particular situations where a waiver on compassionate grounds could apply. That's directly what's proposed in the amendment. It's also time limited, so it specifically says over 5 years. So we're not talking about people who are just a day over what is like a standard processing time. But if the department were ever to set a standard processing time of 5 years for an application, I think most of us would find that ridiculous. And I've recounted this story now multiple times, but I do have a constituent who has a TRV application for a family member to come to Canada. 1,113 days is what it was in the system when they last checked a few weeks ago. And that's an incredibly long time to wait. It's not quite 5 years. And in that particular situation, that wouldn't apply. So because it's so limited, I think providing the executive the ability to waive is actually reasonable. Because it's a very small group of people. So if you just use citizenship ceremonies, out of 294,000 citizenship applications in the system right now, how many of them, are over 5 years? It could be a very small pool. And how many of them there's compassionate grounds? We saw just a few months ago that, I'm going to get the acronym wrong, either GMCS or the CIMM system. There's lots of acronyms in government, that there were up to 60,000 files that had a code assigned to them, and sometimes these were employees who were no longer working. The oldest file that was still open was 2006. 2006, that person, whoever they are, has been waiting a very long time to have their application processed. That is an inordinate amount of patience that someone out there has with the IRCC department. And, I know 2006, there was a different government charge. So it's not as if it's related. It's like this is a bipartisan issue, I would hope, like my colleague said. This would provide a very narrow scope for a minister to use a very broad range of factors to determine, compassionate grounds. I don't know if there actually is a definition that is being used in the legislation. What are compassionate grounds? I think it's broad enough that a minister could determine whether in a particular situation applies. It has to be over 5 years the person has waited for a response from the department, and we hear this constantly. That's the reason people come to members of parliament. They have emailed, they have called, and there's nobody responding to them in any way. So I think this provides an out, and like the debate in the House when the report was considered on expanding the scope of potential amendments to this legislation, this is, like basically a statutory review of the Citizenship Act. We could insert this in here, and the moment this receives royal assent, if this passes through the House, passes through the Senate, the minister would then have the ability to use this particular power. And, we could even set out what types of rules would need to be considered. I'm sure that, I have sent the minister a public letter back in April 13 of Iranian spousal sponsorships. I think this could apply in cases of the Ankara visa processing office where Iranian nationals whether they are Azerbaijani, whether they're Persian, Kurdish, or Baluch. They are waiting multiple years, some over 5 years, and there are compassionate grounds for them to receive a waiver of some sort. Now, my interpretation is could potentially go beyond Citizenship Act applications. If someone wants to make a sub-amendment to limit it only to citizenship applications, perhaps that could be done here to stay within the title of the act. I don't think it's necessary. There's also, I know a lot of Turkish exiles who I've met who have waited multiple years in third countries. Some of them are not safe countries that they're in right now. And they're waiting to hear back from the IRCC department so they can also come to Canada. And they're fleeing the Erdogan regime, which I note Erdogan's re-elected once again. I have a lot of Kurdish friends who have no time for his authoritarian politics. And I'll note also, I have not a constituent of mine, he's actually a constituent of another Calgary MP who wouldn't help them on their Group of Five sponsorship. He actually is from the Skyview area. It's a Kurdish man who was trying to do a Group of Five sponsorship for his family members, and he waited 3 years just to get a no. And that could have come a lot faster for him because he had, bonded, he had cash that he had set aside to demonstrate to the department that he'd take care of them. He was at the 3rd year mark, and he wouldn't even be covered by this provision. And that was like, he told me, $24,000 for each family member that he had demonstrated to IRCC that he was willing to set it aside and had the funds necessary. He's been incredibly successful. It's one of those great kind of like success stories in Canada, but he wouldn't be able to have his family members apply to get an answer, or in this case, a waiver. There is another method for a person to get an answer from the IRCC department. That's to go to court. And I don't have the legalese text. There is a Latin word for it when you basically go to court to get them to force the department to give an answer. I'll note that those cases are way up. They're over 1,000 right now. So this just gives another avenue to avoid court. And I think that's why I think this is so reasonable. It's limited in scope. It provides the minister a very limited discretionary power that Parliament is governed by. I don't believe there's a definition in the Act, and I'm going to turn to the department. Is there a definition of compassionate grounds in the Citizenship Act that this could refer to?
Ms. Gerard?
Madam Chair, there's not a definition in the Citizenship Act, but I would note that the minister already has the discretionary authority to grant citizenship for reasons of hardship, and that is a broad, flexible concept for some of the reasons that have already been mentioned. Thank you.
No, I'd actually just follow up, because in cases of hardship, thank you, Madam Chair, but in cases of hardship then, would it cover, does that person have to have an active application in the department, or could they have no application at all?
Madam Chair, it requires an application.
So that then the example, I would use then, and I did put it on notice many months ago now, when his case was concluded and he was sentenced to 25 years in a Russian gulag. But Vladimir Karamurza, who's the same age I am, who has 3 kids, he's one of the Russian opposition leaders, him and Alexei Navalny, both of them are facing basically imprisonment until death. And in their situations, they don't have an application in with IRCC. They could use it if they had it, and it was over 5 years, they could seek this type of waiver. But there are many types of different situations. This one is specific, I think. If it's not described in the Act, that's a different method of doing it. This is a waiver on compassionate grounds over 5 years. I think it's infinitely reasonable in the way that it's written, and that we should support it, because that would help our constituents and would help families in Canada. And there are people, I'm certain, who have citizenship applications who've been waiting a long, long, long time. That's a different type of lost Canadian. If they've been here 18 to 20 years and they're waiting over 5 years to have their citizenship confirmed after they've taken a test and done everything they're supposed to do, they can just apply for a waiver if this passes. So I think it's a good idea, and I want to support it. Thank you, Madam Chair.
Thank you, Mr. Dhaliwal? Mr. Dhaliwal, we cannot hear you.
Can you hear me now?
You turned off. We heard you, and then it's turned off again. Can you? We can't hear you, Mr. Dhaliwal.
This new phone.
Yes.
Hello, can you hear me?
Yes, we can hear you now. Please go ahead.
Thank you, Madam Chair, for recognizing me, and I also want to thank Honorable Rempel Garner for thinking about these spousal cases. And I want to wish Mr. Garner well with his surgery. Madam Chair, there might not be many people who might recall the conservative way of abolishing or diminishing or cutting the waiting list or backlog. I still remember, Madam Chair, it was the previous government before 2015. If I'm correct, it was Mr. Harper's government, and that was a conservative government. And Madam Chair, what they did? The minister had a power. He came in one day. There were almost 250,000 applications in waiting. And you know what he did? He came in with the press of one button. He said that we're not going to consider any of those applications. All those applicants that were waiting in line were gone. And I still remember, because I was an MP when Mr. Harper was in power, previous government, it was taking almost 2 to 3 years for a spousal case to process. In 2015, when Liberal and Prime Minister Justin Trudeau, took over, they brought in a policy that the spousal case, every spousal case, 99% of them will be cleared in 1 year. And Madam Chair, it happened. Spousal processing time from 2 to 3 years under conservative came down to 13 months. And sure, under COVID, it went up, and now Minister is bringing back, bringing families together. This is the first time last week. In fact, it's a recent announcement made by the Minister of Immigration.
J'ai eu une bonne discussion avec le ministre de l'Immigration.
Translation issue. Can you just stop for a minute? It was French coming in. Mr. Dhaliwal, can you please say 1 or 2 sentences just to check the translation?
Certainly, Madam Chair. I'd love to say a few sentences before I go back to the topic. I hope the translation is working well.
It's working. Yes, please go ahead. Mr. Dhaliwal,
Thank you, Madam. Thank you, Madam Chair. Madam Chair, I was talking about the bringing spouses together, and it's just a recent policy announcement by Minister Fraser recently, last week, that anyone whose application is in the queue, they will be able to apply for a TRB, and they will be issued TRB. And I'm sure, Madam Parliamentary Secretary to the Minister who's sitting with us today, she will witness that I had a good discussion with the Minister yesterday about this, and now the spouses will be able to come together in no time. And I haven't seen that certain policies, under the previous government. And more importantly, Madam Chair, I was talking to my dear friend, Mr. Ali. He was very excited to attend many of the citizenship ceremonies last week when he was in his riding, and I'm sure there are many other members that were attending those ceremonies. But most importantly, the question raised by Madam K. Baga, what has this to do with lost citizenship? That is my question as well. I think if Conservatives want to take longer, I think they can probably borrow it from my dear friend Bruno de Sepp. He had a novel there. He didn't finish previously, and they can borrow that novel and carry on. And I would suggest that let's.
Sorry for interrupting. Sorry for interrupting, Mr. Dhaliwal. The meeting you are quoting was in camera, so you cannot talk on that.
Okay.
Thank you.
Thank you.
Are you finished?
Thank
Yes.
you, Madam. Thank you, Madam Chair, for reminding. That's all I wanted to say. Let's don't waste any more time. Let's get this important bill through so the people who are lost Canadians, lost their citizenship, they should be able to regain this. And I'm sure Senator Martin will be very happy as soon as this bill goes through and she puts her name and stamp on this bill.
Aliwal, next on the list is Ms. Kwan.
Thank you very much. I want to say pain in so many ways. Madam Chair, first off, I want to say this. There's no question for people whose application is faced with processing delay that there should be a mechanism to deal with them. I absolutely agree with that. Now, before I go on with further comments, I want to actually ask the legislative clerk for clarification. With respect to this amendment here and the way in which it was explained by Ms. Rempel-Gardner, is this to say that this will now apply for all applications, whether it's PR, work permits, study permits, citizenship, anything, where there is a processing delay of over 5 years, that the matter would be automatically be referred to the minister, or that there is an ability to refer the matter to the minister to review the cases and then waive those delays and approve the application. Is this what this means? So my question is to the legislative clerk, please.
Thank you, Ms. Kwan. The legislative clerk has said that this refers to the official, so I will ask Ms. Gerard to please respond to Ms. Kwan's question.
Yes, Madam Chair, thank you for the question. This amendment is seeking to amend the Citizenship Act. The scope of the Citizenship Act refers only to applications in process under the Citizenship Act, which specifically refer to grant applications in particular. So I just wanted to take the opportunity to clarify that. Thank you.
Well, thank you very much. Thank you very much, Madam Chair. That's very helpful because it clarifies the muddiness that's been presented as though that this would apply for every other case and every other stream. That clearly is not the case. Now, of course, I would be tempted, although I'm not going to, so you don't need to respond to the officials, to ask, how many people are in the situation of having to wait over 5 years for their grant application process and so on and so forth. But the officials are not here and equipped to answer those questions because we're here to deal with lost Canadian issues. And so I would be happy to entertain these kinds of suggestions in a different time and even for a study if people want to sort of take a look at that and to initiate that process. I would also say that for people who need urgent, perhaps, and recognition for citizenship, such as the examples to which Mr. Kimmich has mentioned. There is, of course, a provision to which that could happen, and that is honorary citizenship, to which the minister has the authority to grant as well. So, and because citizenship applications do have a hardship component within it, to which the minister can exercise that right to look at those hardship cases for delays, I think that at this point in time, we should focus in on what is before us. That is the lost Canadian issues. I'm tempted to bring forward all manners of amendments that would be outside of the scope of S245, but something that I really want to see through, such as, for example, an amendment to deal with statelessness. But I recognize that that maybe I would be not doing that appropriately and therefore undermining the very people who's trying to get their situation addressed, and that would be the families with lost Canadians who's been waiting patiently to watch to see what this committee does. And so to that end, I will not be supporting this amendment, and I'm hopeful that we can actually get through today by 7:30 the entire package of all the amendments that's before us.
Thank you, Ms. Kwan. I have 3 more people on the speaking list. Just before I go, I would request all the members to please stay on the topic. Like we are dealing with Bill S245, an act to amend the Citizenship Act. All your comments should be please within that scope. So the next on the list is Ms. Rampel-Garner.
Thank you, Chair. I'll use my time to respond to a few questions. So I'd like to draw colleagues' attention to the instructions given from the House to this committee on the review of the bill based on a motion that was passed in terms of how this committee should be reviewing the bill. And I think this is important for people who are watching. So the motion, which was voted on in the House of Commons, that I voted against, but others voted for, was that the committee report the following to the House, that the committee recommends to the House, sorry, this is the motion that we passed here, and then there was a subsequent reflective motion in the House, that the committee recommends to the House that it be granted the power during its consideration of Bill S-245, an act to amend the Citizenship Act, granting citizenship to certain Canadians, to expand the scope of the bill such that the provisions of the bill not be limited to an application to retain his or her citizenship under Section 8 as it is read before April 17th, 2009. So I just want to be clear with colleagues that, and I want to reiterate arguments that I made earlier, the standing orders and rules and procedures regarding review of bills typically is that amendments are focused on the very narrow substance that is included within the bill that's presented before our committee. What this committee, and then subsequently the House, decided to do was to expand the scope explicitly to go beyond those provisions. So my colleague, Ms. Kwan, argued that this wasn't in scope, but it is in scope. This amendment is in scope. So essentially that's what she was intimating, and that it didn't have anything to do with the bill. But what we are now looking at for people who are watching is that what happened here was that rather than the government introducing, they could have even put it in the Budget Implementation Act, frankly, if they wanted to. Instead of the government, what I'm guessing happened is that part of the NDP Liberal Coalition deal was that they made a bit of a behind-the-scenes deal on what needed to go into this private member's bill, which was very narrow in scope. And again, just to reiterate, my understanding is from Senator Martin that this was expedited through the Senate with all-party consensus so that the bill could go through. My understanding is that stakeholders were like, yep, let's keep it narrow and to the point so that it can go through. But what happened here was when whatever deal was made to assuage whatever, that this now the subsequent motion on how this bill would be disposed with was passed before this committee and the scope was opened up. So what is good for the goose is good for the gander. And since we have now increased the scope of the bill, we all have the right and frankly the obligation and duty to follow the terms of that motion, which is what this amendment does. It is completely acceptable. It deals with the matter at hand, and I am following the order presented to this committee. Now, I want to be clear that many of us, when we were deliberating this particular motion, we made the point that we should be carrying forward in the spirit of nonpartisanship and out of a desire to help the people who Senator Martin set out to help. We all want to do that. When we debated this motion to increase scope, there were concerns that were raised, such as my colleague, Ms. Kwan, said that the department officials wouldn't be prepared to look at amendments. Well, now members of the opposition have been forced to look at very technical, very substantive changes to the Citizenship Act with table-dropped amendments and without data on impact, on costing, on terms. And I understand the intent is to help people here, but my job and my first responsibility, my fiduciary responsibility to the Canadian public when I'm reviewing legislation is to understand things like cost, like what is the role of government? What is the impact? Does this impact one group of people and not another? Is this going to cause downstream problems? It might not, but I don't have that data. That is why the standing orders usually restrict amendments to a narrow scope of a bill. But what we've done here is said, be darned with the standing orders and the review of legislation. We're just going to open this up. Now, what I've done with this is try to put in place a very common sense amendment that does actually affect the scope of this bill as well, too, because we know that even people who are in this boat, lost citizenship or lost Canadians, that they also are subject to the same delays and same incommunicado status that we often get from the department. So I just want to be very clear to anybody who is watching. I take my duty to review legislation very seriously, and opening up the scope of the bill to put things that weren't in scope on a bill that was already agreed to in the other place puts me in a situation where I am not prepared to vote appropriately without due diligence. And that due diligence will happen here. This is not any sort of game outside of, it is not fair for me to be put in a position to vote on legislation without due diligence. And when there is an opportunity, when the committee has voted to essentially do a statutory review of the Citizenship Act, then that is what we will do. And we will take the time to do that, because we all have the same rights on this committee to do that, opposition, in a coalition agreement or not. We all represent close to 1 million, well, roughly. I represent 120,000 people in this room. We probably represent close to 1 million or over 1 million people. For us just to push this through because somebody in some backroom deal says we're going to increase the scope because their private members bill didn't get through in the last parliament, that's not my problem. I have to make sure that my constituents, that I'm doing my diligence, and I'm not sorry for that. My colleagues have been asking very good questions. Frankly, we haven't even received responses to on some of the data that we've asked for. We've been put in a position to vote on amendments that were done in a deal, and frankly, we've now had a point of privilege on this matter with stakeholders when we weren't even looped into the matter. I find this atrocious, the whole process atrocious, and I will try to maintain my composure here. But for somebody to intimate that it is somehow not appropriate to follow the letter of a motion that they themselves put forward and voted in favor of, well, they have another think coming on how this is going to proceed. We are going to proceed with diligence and also undertake the order of that ruling. If they wanted to push this through quickly, then what should have been done was then we could have relied. We could have relied on the work that was done in the Senate, right? Because it was done quickly and with diligence. But that is not what is happening here. What happened was, let's put in place a whole bunch more amendments that are out of scope and then expect everybody around this table to vote without doing that diligence. And that's just not fair. It's not right, and that's why there are rules and order. So, this amendment here, back to the matter at hand, it is in order, based on the instructions to the House, 1. 2, it does impact the people who are with the original scope of the bill. The staff here have, to my colleague Ms. Kaya-Vaga's question, talked about scope in terms of what it would apply to. And 4, I'm just going to argue that the minister, some people have said the minister may already have certain powers or whatnot. It's not clear in this regard. And there's nothing in the Citizenship Act that talks about processing delays. It's a very unclear, nebulous process on which the minister can and can't do this. And then what happens is that when we are communicating on this with constituents, or if there's immigration lawyers that are looking at this, they are unclear as to what and when the minister may intervene. I would like more clarity. And that is why this motion is here right now. That's why we're seeking to amend this act. Colleagues, we will, if other colleagues are looking at amendments that are far beyond the scope of the original bill, then so will we. And again, I want to reemphasize, Chair, that should the government have wished to have done this, they could have put any other amendments in the Budget Implementation Act, they could have put in place another piece of government legislation, or people could have put a private member's bill for, but that is not what happened here. They changed the rules of Parliament, essentially, and now we are just responding to those changes. So, I hope that my colleagues will support this because it gives the minister additional tool. It recognizes the fact that oftentimes the department doesn't really have any political imperative to maintain service standards, even within a narrow scope. It clearly gives people who are stuck in quagmire situations, as ones that we've been discussing in the scope of this bill, some hope. And I would hope that my colleagues would give the minister another tool and give people some hope. Thank you.
Thank you, Ms. Rempel-Garner. Next is Mr. Redekop. Mr. Redekop.
Thank you, Madam Chair. I'm not going to rehash what my colleague, Ms. Rempel-Garner, just said. I think she said it well. But I do want to just remind us here and anybody that might be watching, we were on a certain track. The track was the Senate had provided this bill to this House without even studying it, because they knew the content of it. It had been previously gone through the Senate. And so they entrusted it to the House. Why did they do that? Because they wanted it done quickly. Everybody agreed this needed to be done quickly. And so that was the track we were on. It came here. It was one of the key issues on Lost Canadians. Was it all the issues? No, of course not. It was one of them. But that was the whole point of it, was that rather than fix everything at once, we were just going to, the sponsor of the bill wanted to fix one significant chunk of this problem and actually get it done, because this has been attempted numerous times to fix, and it's always there's always been too much bitten off, too much attempted to fix at once, and it's never made it through. And so it was a new strategy this time to keep it simple, focus on one thing, go through the Senate quickly, now come to the House. That was the track we were on, and here at this committee we would have looked at it. I think there was broad agreement for what was in that bill. And once we had completed with it and sent it back to the House, and had the House voted in favor, that would be the end of the story, and it would have actually been implemented. That's the track we were on. Now, the track we are now on, because of, as my colleague described, the motion in the House to expand the scope of this, because the government and the NDP and whoever else wanted to go back to the former strategy of doing everything at once. You know, if at first you don't succeed, trying again, except the definition of insanity is doing the same thing multiple times expecting different results. So what has happened now is that we've expanded the scope of this bill broadly. And so yes, it's taken longer to get through committee here, but this isn't the end of it, because the track we're now on, should it be voted through the House, it's going to have to go back to the Senate, and the Senate will not just rubber stamp it. We already have indications.
Madam Chair, I'm so sorry. I would like to pose a place. I'm going to do a point of order.
Sorry.
Point of order, Madam Chair.
Yes, Ms. Lalonde.
Listen, I'm a very big proponent of l'histoire et les cours d'histoire, mais je pense qu'ici...
History and history courses, but I'd like my colleague to get back to the motion presented by his colleague.
Discussion on history, Madam Chair. Let's go back to the point that we are having a conversation, which is my colleagues. Merci.
Madam Chair, with regard to relevancy, both my colleague Ms. Kayabaga and Ms. Kwan, in their remarks, raised questions about process and scoping. I believe that my colleague's comments are relevant because he is talking about how the expansion...
It's not a point of order?
It was on the point of order, just before you make a ruling. That's all. So I do get to intervene, correct?
Yeah, so that's what I'm saying, that we are getting into debate. So this is not like a point of order, it's getting into debate. I will go back to Mr. Redekop.
So, yeah. So, and the reason I'm going through this is because of exactly what was just said. The questions were why do we seem to be going beyond Lost Canadians? And so I'm just reminding.
Just to remind, as I said previously, also let's everyone should stay on the bill we have before us. So let's not go into too much of the other side discussion. Let's focus on the bill which we have before us.
Okay, but Madam Chair, the questions that were asked were why are we going down this path that isn't directly on the subject of lost Canadians? And that's part of the answer to that question that has been asked. And so that's why I am, I'm trying to answer that question as to why we are going down that path and reminding the committee of the path that we are now on. And so the significance of this is that because we're now on this other path, so I've explained that, and it's going to take longer in the Senate, and it's just a longer process, and the odds of this actually finally getting approved are getting smaller because of the longer process due to this path. The other point of this path is that, as my colleague, Ms. Rempel-Garner, just explained, now we have the ability to do the same, because it's a fair point. You don't often have a chance to change things in the Citizenship Act. And so just as the government and the NDP have said, hey, let's fix problem 2, 3, 4, and 5, I think this amendment that's being proposed is problem 6. Because we have a few ideas as well of things that we would like to do since we've opened the hood, so to speak, on this Citizenship Act. Now we have the chance to throw in our few cents about what we think should be fixed, and this is one of the amendments that we've discussed. And so I think it's perfectly relevant for us to suggest something like this and to get it done. So for that, I support it.
I have 2 more people on the speaking list, just to remind all the members that right now we are debating on the amendment moved by Ms. Rempel-Garner, and I would request all the members to please stay on that amendment. It's Mr. Kimmich and then Ms. Kwan. Mr. Kimmich.
So just to reiterate, there's 294,000 citizenship applications that are backlogged right now that this could apply to, and there must be some that have extensive delays assigned to them that this would directly help. My colleagues have raised the issue that all this is germane to the discussion. We're trying to find ways to propose amendments that will, when we go back to our caucus to seek, caucus solidarity, that we can all vote for the final product that this committee produces for the House to consider, that our Conservative team will be for it, because when this went through our caucus, it was basically, it's what we call a slam dunk. Everybody agrees. We agreed with the original principle and scope of the bill, and we were on side because there were 2 different versions of it. This amendment would help us make the case that the other portions of the amendments that have been introduced, that have passed over our objections, that this would help us say, okay, we got a few things we like, there are some things we don't like, but on balance, it is perhaps a bill that we can live with and on a go-forward basis. And this amendment does exactly that. We would be able to achieve that, I think, with our caucus, but we have to go back and convince them that this bill has been used for other purposes, to expand to other groups of lost Canadians. And we've been very amenable. We voted for some amendments, like the previous one on matters of adoption, which, after asking a few questions just to get a better understanding of it, we as Conservative members, we are for it. It can't be said that we haven't been reasonable when there was reason, but there are other amendments that we could not agree with, and those will be amendments that our caucus colleagues will then look at and say, well, why did these pass? This is not what was originally agreed to. They go far beyond what was the original scope. We'll remind them what happened in the House. I mentioned in the House that this would essentially be treated like a statutory review, so why not put in a compassionate waiver provision for the minister to consider? That's almost 300,000 applications right there. When there's a backlog of almost 2 million, that's still a large amount that could be considered. And who knows into the future how many more extra ones could occur. I think and I'm hoping that the IRCC, the department, and the minister abandons the plan to do that click citizenship, the attestation format, that we move back to in-person ceremonies. I know they are maybe more difficult to do, or maybe it's more inconvenient to hold in-person ceremonies, but I think they're important because, again, I had a naturalization ceremony back in 1989. I think they're very valuable. It's the 3rd word in the department's name, and it's the first one in this committee's official name, citizenship. That's the whole point of immigration, is to make new citizens in Canada, and that's what we want. And providing a waiver for some of these applications that are massively backlogged, and again, only those over 5 years. It's a very narrow scope. Only those over 5 years, only those on compassionate grounds. Maybe there are certain situations where a person missed a lot of ceremonies that they were invited to. Maybe they were invited to a virtual one and they dropped out before it could be completed. I know that would be a problem as well. So because it's narrow scope, because it's a delegation of a little bit more executive authority by Parliament in the Citizenship Act to the Minister of Immigration, Refugees and Citizenship, it's only for waivers on compassionate grounds, only those over 5 years, only for citizenship applications. That's what I've come to understand would be the general interpretation of this. Like, I don't see why not. It's a reasonable amendment, and it would help us go back. I do want to remind you, Madam Chair, because you allowed another member from the opposite side to speak, and I have a great appreciation for Mr. Dhaliwal. He is a veteran of the House and has been here for a long time. But I will remind him that actually the numbers for parents and grandparents, family class PRs is 39 months right now. That's according to data that was sent to this committee by RCC, and 16 months, March 2023, 16 months, spouses, partners, and children applications. So it's way beyond the 12 months. And I'm going back to 2019 for when it was 12 months, very, very quickly. So there's been long delays. And when he spoke about the applications that were returned, everybody's money was returned as well in that situation. We're not talking about returning the 294,000 applications for citizenship, their money and their applications here. That's not what we're doing. We're creating a waiver here. But remind them that that was a Liberal backlog that was created, and the Minister of Immigration at the time returned everybody's applications and reset the system because there was no other choice. It was so backlogged because of what the previous Liberal government had done under Prime Minister Paul Martin, and it completely jammed the entire system right up. So that's just a reminder of history, and the numbers they have provided are not correct. But I did check today, and again, 294,000 citizenship applications. Let's vote yes for this and move on to the next one. I think it's entirely reasonable. Thank you, Chair.
Next I have is Ms. Kwan.
Thank you very much, Madam Chair. I'll just say very briefly that the amendments that are out of scope pertaining to S245 on the lost Canadian issues were items that actually I did bring to the attention of Senator Yona Martin, actually, and had a discussion with her. And she had indicated that she would support that if I'm able to get the government support. And I understand, and she's advised that she has met with the minister in this regard as well. Now, I know that there was a last-minute change of mind, literally last-minute change of mind, and then, and for her respect, out of respect for her colleagues, her conservative colleagues around this table here. With that being said, though, you know, my focus here is and has always been and has never actually, I think, at any point in time throughout this entire process, that the minute that S245 was tabled or was coming, I had indicated that the scope was too narrow and we needed to actually address these other things in terms of specifically related to lost Canadians. Now, to this amendment here, like I said, I would be happy to entertain this in a different arena. Not to say that you can't bring out of scope amendments to S245. Yes, you can. But I myself had indicated to everyone that the amendments that I intend to bring forward is related to lost Canadians. And I was always open and transparent on what my intentions were with anyone who cared to talk to me about this. So to that end, Madam Chair, I'll reiterate that I will not be supporting this amendment.
Thank you, Ms. Kwan. Next I have is Ms. Rempel-Gardner.
Thank you, Chair. I'd like to respond as well to some of the assertions of Mr. Dhaliwal as well as Ms. Kwan. So my colleague, Mr. Kimek, had also, I think it was important to put on the record that the current backlog for spousal applications is, I think it's 39 months.
Yes.
So it's well beyond the time frame that Mr. Dhaliwal asserted to. I think that's very important to have on the record. As well, just to respond to Mr. Dhaliwal's comments, which were ruled in scope. What happened at the end of the Chrétien-Paul Martin government was that the immigration system was so backlogged that essentially what happened was anybody who applied to come to the country was on a no-hope waiting list. It was kind of like saying, yeah, apply, that's fine, but you're never going to get processed. There was really no hope of being processed. And we're now in the same situation, again, 8 years into a Liberal government. In 2015, at the end of the Harper government, there was under 100,000. I think it was well under 100,000 inventory caseload. Now we're in the millions again. So I think that's very important to clarify. The other thing is I want to, just for Mr. Dollywell's sake, it was also this government that on family applications, I believe the government tried to put a lottery in place, a very unpopular lottery, where people were essentially randomly allowed to come to the country, which is eminently unfair. I think it's very unfair to intimate to Canadians, set immigration targets such that even if people apply, they're never going to get processed to come into this country for a decade or plus, or whatever the waiting time is now. That's what should happen is that if we are setting immigration levels, the processing timelines should be such that people actually have hope and can plan to enter the country. And I think recognizing that fact that there was a no-hope wait list that the former Liberal government had put in place was very important. Because across political lines, we all understand that immigration is important to this country. We need to ensure that there are expeditious but rigorous processes in place to review applications. But I do think it was a little bit revisionist history on what happened, as well as what the current status is. So thank you for allowing me to respond to that comment. The last thing I'll talk about is Ms. Kwan's comments. She said that she, and I'm going to try and convince her to vote in favor of this motion, that she would consider this in other arenas. Well, what other arena? This is the arena that she asked for when she voted to expand the scope. Now, she said that she didn't ask for amendments that were beyond Lost Canadians, but that is precisely what the instructions in the motion said, precisely what it said. It's amendments to the Citizenship Act. So this is the arena, per the instructions from this committee, to look at amendments like this. So now we have a common sense amendment on the floor. I've heard no arguments against it. I've only heard arguments around process. So I really think that at this point, if people are voting against this motion, it's some sort of, I don't know, coalition deal. And I just think that now that we are going through this process, there are common sense amendments on the floor that make a lot of sense. Any voting against this is preposterous, frankly, particularly since through all this discussion today, nobody has given an argument against it. So I think that any voting against this motion is frankly partisan in nature. This is a no-brainer amendment, and it's exactly what this committee asked for when opening up the scope of this bill. Thank you.
Thank you, Ms. Rempel-Garner. Just to give everyone like a 5-minute break, like I think people need to go to the washroom and like have a cup of coffee. So I have Mr. Kimmich on the speaking list, but I will suspend the meeting for 5 minutes so that everyone can have like a little break. Thank you. We have the amendment moved by Ms. Rampal Garner on the floor. And next on the speaking list is Mr. Kimmich. Mr. Kimmich.
Was to just rebut one point made by Ms. Kwan. I spoke with Senator Yona Martin just this morning, and she doesn't like what's happening with her bill. So just to reiterate the point she had made, the amendments to her original parts of her bill were entirely okay with her. It was the correct wording that the department deemed necessary in order to address the original principle of her bill. which was to help that small group of lost Canadians between 1977 1981. Those were the people they wanted to, and we got expert testimony from the department that the new wording was necessary. She was okay with that. Now we are going through clause by clause, amendment by amendment. The scope has been expanded, so we can consider other matters that would reduce the number of lost Canadians, that would, reduce the potential for a person to be stuck in an endless queue on their citizenship application. And this waiver that's being proposed on compassionate grounds, I think, meets the principle of the bill. It's well within the scope of the bill. I will also add that in testimony at the Senate, at the time, there was discussion and debate, and one of the witnesses said, that said, if amendments would delay the passage of this bill, then please pass it as is. Since we're not doing that, it will take a little bit more time. And in the grand scheme of things, grand scope of things, I'd rather do a good job this time to make sure all the matters that we would like to consider for lost Canadians and changes to the Citizenship Act, like I've said before and I said in the House, I consider this now a statutory review, that we do this properly instead of quickly, because quickly usually leads to unforeseen consequences. I see an opportunity here to plug in our hole and help stop more future lost Canadians. Thank you.
Seeing no further debate, we will take a vote on the amendment moved by Ms. Rempel Garner. Mr. Clerk, if you can please take the vote. We are voting on the amendment moved by Ms. Rempel Garner. Thank you.
Mr. Ali.
Against?
Mr. Dhaliwal.
Against?
Monsieur El Khoury. Madame Kayabaga.
Contre.
Madame Lalonde.
Contre.
Mr. Kmitch.
For.
Mr. McGuire.
For.
Mr. Redekop.
I'm supporting this.
Ms. Rempel Garner.
In favor.
Madame Larouche.
Je m'abstiens.
Ms. Kwan.
No.
Yeas 4, nays 6.
The amendment is defeated. Now we will proceed to NDP 9. Ms. Kwan, would you like to move that?
Madam Chair. Sorry, I'm just going to find the page here on NDP 9. Sorry, I think the next one that I'll go to will be NDP 12.
Point of order. Point of order. Just wanted to advise you that we have an amendment to do after NDP 9 before we move to the next one. So just.
So just one, you are not moving NDP 9.
I am not.
Mr. Redekop.
Thank you, Madam Chair.
I'm getting French.
Okay. So I want to move the following amendment, and it would look like this.
Do you have?
It's just coming around to you now. It's a new clause 1.1 that Bill S-245 be amended by adding after line 18 on page 1 the following new clause. 1.1, Section 5, bracket 5 of the Act is amended by replacing paragraph 5, bracket F with the following. F, has not been charged with, comma, or on trial for, comma, convicted, comma, subject to or a party to an appeal relating to an offense under subsection 21.1 bracket 1 or 29.2 bracket 1 or bracket 2, comma, or an indictable offense under subsection 29 bracket 2 or bracket 3, or any other act of Parliament outlining criminal offenses, comma, other than an offense that is designated as a contravention under the Contraventions Act. And I'm happy to speak to it if we want to take a moment to make sure we've all got the proper paperwork.
Do you have it in both languages?
I do. They're right here.
Okay, so We will have to get this circulated to all the members. So I will suspend the meeting for 2-3 minutes so that it can be circulated to all the members and members can have a look, and then we come back. So the meeting is suspended. I will come to you, Ms. Lalonde, after that. Thank you. amendment. Hope everyone has got that in both official languages. So we have the amendment on the floor. Ms. Lalonde was on the speaking. Okay. Yes, Mr. Redekop.
Thank you. Thank you, Madam Chair. So just a little background on what's going on here. So if you look at the Immigration Act, Section 5, bracket 5, the headline in there says statelessness, bloodline connection. So it's talking about granting citizenship. And if you look at Section F, which is the part that I'm proposing that we amend, it does list some offenses that, and it says you have not, a person can be granted citizenship if they have not been convicted of some offenses, and then these offenses are listed. It talks about terrorism, an offense under a very specific section of the criminal code, or an offense under subsection 5.1 of any another different.
Everybody's having trouble with smartphones today.
That was our glitch. Sorry.
We were due.
Yeah, it was our turn. So, and so it basically what it does is it lists some very specific offenses here. And so what I'm proposing in my amendment is to simplify this a little bit because you can ask the question, why would we not grant citizenship to somebody who has been convicted of this offense, but we would grant citizenship to somebody that has been convicted of offense B? Why the difference between the two? And so I think if you look at that, what my amendment is proposing to do is to basically say that if you have been convicted of anything that is a criminal act, so in common terms it would be with anything with more than a 2-year sentence. Doesn't matter what it is, any criminal offense that's a federal crime, that would be the test. And so rather than cherry picking this or that or the other thing, it would simply be if you've been convicted of a criminal offense is essentially what that is intended to do. And I think it simplifies things a little bit because you're not cherry picking certain offenses to say one is better than the other or whatever. You're saying that if you've committed a criminal offense that's more than 2 years, that would be the criteria upon which you would not be given citizenship. And I think there's some very good reasons why we would want to do that. We don't want to be bringing in, granting citizenship to people who have criminal records. That doesn't make a lot of sense. If we do that, it can create a lot of headaches down the road. Even from a government perspective, we could end up with a whole lot of extra work in departments, whether it's immigration department or the consular department or other things. There's a lot of headaches and complications that come when we discover that we've brought someone in and granted citizenship to somebody who maybe shouldn't have been granted citizenship because of these crimes. And I think one of the things that I think about when I think about this is, Canada has a bit of a spotty record sometimes on things like money that comes in from countries in questionable ways, and a lot of us would be familiar with the Iranian situation right now, and how there's people who would be part of the IRGC in Iran who are now in Canada, and I'm not talking about conscripts here. I'm talking about actual members of the IRGC or their families, and this is just an example of a case where we as a country maybe aren't quite as diligent as we should be on some of these situations, and we end up having people in our country, and in this case we're talking about granting citizenship, who really just shouldn't be accepted as citizens of our country because of criminal background. And I think it's okay for countries to have criteria and have boundaries on what's acceptable, to become a citizen of the country. We have requirements, English requirements and knowledge tests and things like that we require, and this is just another part of that test. And so having this tightened up and having it something that is clear and simple to understand, I think is a benefit and something that we should do. And so the one thing at the very end it talks about contraventions, and just if you're not sure what that is, that's if it's been reduced to a ticket rather than time served, that would not qualify or would not be part of this. So it's basically you've been in jail for 2 years or more. That would be the criteria. that this would be. So that's my preamble to this, and I would move this amendment.
Jacob. Next I have is Mr. Kimmich.
So I was just going to begin by noting that this would basically be kind of like the same idea as the substantive connection test. So we've imposed a requirement by which you could regain your citizenship, basically, and it is like a burden of proof that you have to give. So I think this is very reasonable. It's that burden of proof that a person who, even if they meet the over 1,000 days that would be required, that they would have to then disclose to the department that they've not been charged with, on trial for, convicted, or subject to, or party to an appeal, and then it lays out the offenses that would be excluded. And I'm just trying to bring them up very quickly here just so I can refer to some of them. But it's just 2 years or over. I think it's a pretty reasonable thing to add in. It's just part of the due diligence. I think there would be a huge problem if there were Canadians or former Canadians then who are overseas, who maybe have, there's lots of honorable people who move on and go on to do other things overseas. They join different international organizations. They move for family. They move for love or what have you, or they're pursuing their careers or a better quality of life somewhere else. So I think that's reasonable. But in certain cases, some of those people do get involved in criminal organizations and criminal acts. And we would just want to make sure that they don't have a method of regaining their citizenship. I imagine this will be, again, a very small group of people who will be excluded by this extra provision. It says, or an indictable offense under subsection 21(2) or 3. And it really refers to people who have done already something wrong or could have done something wrong. Because if you're charged with an act, you'll have to wait till basically the end of your trial, and you'll have to have exhausted appeals. And so we will know, based on the judicial system in another country, if you've been found to be innocent or not, and then we take that at face value for what it's worth. So I think it's very reasonable. I think it's a method of protecting the Canadian population and Canadian citizenship from having potentially people who may and the one I'm thinking most of, and because we had a federal court of appeal today rule on this case, that Canada actually doesn't have a requirement to repatriate those 4 ISIS fighters, the suspected ISIS fighters, including one of the Canadians, Jack Letts, is among those 4. They went to go fight for Islamic State. I have a lot of Kurdish friends who are from Rojava. Many of their families were affected by what ISIS did, and they don't want to see these people be forced the government to return. So I'm glad this court found in favor of the government. So I'll say a nice thing. I'm glad they found in favor of the government. The government is right. I've always been told that a federal court of appeal is somewhere where the best judicial opinions are laid down, because many of these people have extensive opinions. They're actually asked to interpret Supreme Court rulings at the Court of Appeal, because that's where the final decisions are made. So I think this is reasonable. It is basically my understanding would be 2 years plus would be those who would be excluded by this provision. I imagine it's a very small group of people. But again, it's just for the safety of Canadians that we can increase it. Because it's a small group of people, because it's very limited, again, completely germane to the issue, just add something else to the substantive connection test. I'm going to support it. I'd ask members to support it too. It's something we actually have talked about with other members of other parties that we thought would be a reasonable thing to do. So we're introducing it here. I'm glad that my colleague, Mr. Redekop, pushed for it.
Thank you, Mr. Kimmich. Next I have is Ms. Rampel-Gardner.
Thank you, Chair. I'm supportive of this amendment because when in earlier discussions with officials on some of the other amendments that were made to this bill that were substantive, part of what we heard was that there's really not a clear line of sight. I mean, there's a ballpark, but there's really not a clear line of sight on how many people would be impacted by the amendments that have been made in this bill so far. And I understand that what some of the government sub-amendments that were made to the NDP amendments were essentially to clarify and put some guardrails around some of these things, so that even though we might not have as clear a line of sight on how many people this would impact as compared to the original scope of the bill, that there was clear definitions around who it would apply to and under what circumstances. because we don't have a clear line of sight right now on how many people are impacted, I would like, where I can see this particular amendment having benefit to government operations is on consular services. So with the original scope of the bill, I think that the government had a pretty good line of sight on how many people would be impacted, who they were. What I worry about is now that we've expanded the scope to potentially tens of thousands of people, I would not like to see our government in a situation where they're having to provide consular services to a new Canadian citizen who may be in a thorny political situation or something because we have not defined who this could apply to. As my colleague, Mr. Kamek, said, I do think that this amendment falls within the spirit of some of the other amendments have been made, particularly around the substantive presence test. We've already qualified who this would apply to with the substantive presence test. We're now saying we're adding another qualification. I think that this is also an alignment with other types of definitions that are included in broader immigration policy in Canada as well. This type of information is looked at in terms of applications to come to the country in various other circumstances beyond citizenship. So it's not like we're setting new precedent here. But I do think, again, why I would urge colleagues to support this amendment is that because we have now broadened the scope of this bill so much, and we don't have a clear line of sight on how many people it applies to, it behooves us to ensure that we've got all the guardrails in place so that there aren't serious unintended consequences, particularly given that we have not had time to study this bill or have witnesses appear to testify to some of these expansions in scope. So I urge my colleagues, particularly from the government, I think this is a helpful amendment to the government in particular, to support this amendment. I think that without it, we are lacking a guardrail on qualification. Thank you.
Thank you, Ms. Rempel-Garner. Next I have is Mr. Reddycop.
Thank you, Madam Chair. I guess I've got some questions for the officials actually on this. First of all, do you have I know this is kind of new, so I don't expect you to pull things out of the air too much, but do you have any sense of numbers on this? My colleague just referenced numbers. Any sense of that, either from maybe some past experience on cases like this or things that you may know? So I'd be curious about that.
Madam Chair, thank you for the question. To begin with, I'd like to sort of clarify that 5.5, the statelessness grant of citizenship to which this amendment pertains, is only available as a result of the first-generation limit to a child of a Canadian who's born abroad and who is stateless. And so the 5.5 grant was created as a guardrail or a safety valve when the first-generation limit was put in place in 2009. And it's a rare circumstance and a rare occurrence, but nevertheless, the safety valve is there. And so for the committee's consideration, in general, the number of applications received under these provisions are going to be extremely low. I'll ask my colleague in a moment to give the statistic we have on that in response to the member's question. And in addition, for the committee's consideration, because the provision was created as a safety valve in response to the first-generation limit to a child born abroad to a Canadian who may find themselves stateless for that reason, the new connection test available for second-generation born abroad and beyond, where the parent is meeting a connection test, will very likely have the result that this provision would be used even less than the exceptional circumstances under which it may be used now. Just in response to the member's question. And I'm just going to turn to my colleague Yuen here, who will give the most recent statistic we have with regard to how many times this provision has been used already, as a kind of an order of magnitude in response to the member's question.
Thank you, Madam Chair, for the question. What I can share with you today is with regards to the request for statelessness. Since 2013, we received 8 applications.
Okay, thank you. That's some helpful information. You referred to the substantial connection test that we talked about. In your opinion, would there be value in having an amendment like this on that particular part of the Citizenship Act?
Madam Chair, I'm not going to express an opinion other than to recognize it's open to the committee to legislate. But what I was wanting to get across for the committee's consideration is that generally we would expect the applicants under these provisions to be children in the vast majority of cases. And the only reason that the prohibitions are there is because we can, on the off chance that it is a young adult who is applying, but that would be an even more exceptional circumstance to an already exceptional situation. And then the one other sort of element for the committee's consideration is when we sort of put together the original provisions for 5.5, they were based on sort of criminality type prohibitions that are broadly in line with what our international convention obligations are. And so I'm not certain that any change one way or how any change would affect our compliance, because we're just seeing this amendment for the first time. Thank you.
Thanks. Yeah, that I can appreciate that. That again, the whole reason we're here is because of unintended consequences, and the last thing we would want to do is create new unintended consequences. So I appreciate that. On this subject of statelessness, maybe for those, just to help us out a little bit, could you help us out with an example of the kind of person, like you said, it's younger people. Could you give us an example of how a person would end up in this section 5.5? Like what's the type of person, an example, just to help us out?
Well, in general, the example would be because a child can derive citizenship from either parent, citizenship by descent from either parent. And so the situation may be one where the child of a Canadian is born abroad, because, you know, if they're born in Canada, whatever is the situation, they have citizenship automatically from birth in Canada. But so it would be a situation where a child is born abroad, where they may have a Canadian parent, for example, who is already themselves born abroad in the first generation. You know, that's my personal situation and the situation of many people that we all know. And so if you're the first generation born abroad, you're not able to pass on your Canadian citizenship automatically to your child born abroad, and therefore the discussion we've had in this committee about the helpfulness of a connection test on the parent, and where the other parent, the statelessness will arise where the other parent is not able to transmit another citizenship for whatever reasons due to the laws of the country that other person comes from. And we know that there are places in the world where persons who are stateless come from. And so it's those kinds of examples and cases. And some countries have laws where you may be able to derive citizenship by descent from a grandparent, or parents may have multiple citizenships. They may not only have one. And so that's the reason why really a case of true statelessness for the child of a Canadian would be rare. I'm not saying it hasn't happened, because as you've just heard, we've had a small number of applications since 2013, but that's why it's rare, because you would derive citizenship from both parents and sometimes the grandparents potentially as well. Thank you.
And just one further question: those 8 case examples, generally speaking, are those types of things approved, or like what would be a typical expectation of a case like that?
Thank you for the question. In terms of the status for those 8 applications that I spoke about, 1 has been approved, 1 has been refused, and 6 are pending decisions.
I'm good for now.
So seeing no further debate, we will, Mr. Kimmich.
Sorry, I was going to ask, you said 2013 there were 8 cases? That 2013? Since 2000. Okay, I heard, because I was thinking there were 6 people waiting since, okay, so since 2013 there have been 8 total cases involving this, and you said there's 6 pending. I'm not asking you for who they are. I don't want to know, but you said 1 accepted, 1 refused, and 6 still pending applications. And can we find out how long have they been pending? Is that possible to know? I'm just asking, are these very recently made applications in the last few months, or have some of these been pending for 5 years plus that might need a waiver?
Madam Chair, we don't have that information to hand, but we can endeavor to obtain it and provide it to the committee as soon as feasible.
Merci, Madame la Présidente.
Thank you, Madam Chair. We're talking about another federal legislation in 5.5. Could this be interpreted too broadly? Would it be opening up the door to something that would be inappropriate because this is too broad? I don't know if anyone here can answer that. Inaudible. Madam Chair, thank you for the question. As I was mentioning earlier, this is a provision that has a very limited application. So the amendments being proposed would have an even more limited application, if I can put it that way. And you have to consider that with the committee's deliberations, considering another new connection test for those born to Canadians abroad and future generations, this is a provision that will apply even less in the future than what we've seen up till now with the cases mentioned by my colleague. So I hope that can give you a better idea of the scope of the proposed amendment.
Non, je vous remercie sa réponse.
Thank you. It's another federal legislation. It can look broad, but you have explained the scope very well. Thank you.
Mr. Kimmich?
So I was just going to ask about the conditions of statelessness again, just to follow up, because you said this was only under 18. So, I mean, there's this ugly practice in certain parts of the world of using child soldiers, so they would be under 18. And it would be a series of very unusual circumstances where you would have to find yourself there. But since there's only 8 cases and 6 are still pending, is the case of statelessness, because you kind of described the condition it could be under. So am I to understand it would be countries that do birth citizenship or lineage, like Germany only does. You have to prove that you have some type of German ancestry, and there's this large population of permanent residents of Turkish heritage, and there's quite a large population of ethnically Polish people who live in Germany but cannot become citizens of Germany. So in those situations, a child born there from a Canadian parent, they would be potentially stateless like, I'm trying to understand, is that one of the countries that you could find yourself in a situation of statelessness? Or is it more a country like Dubai that simply has a group of citizens and you cannot be naturalized as a citizen of Dubai if you are from overseas? Is it those types of countries? I'm just trying to understand this statelessness at birth that you could experience. Thank you, Chair.
So without trying to hold myself out as an expert on other countries' citizenship legislation, because I wouldn't want to do that or mislead this committee, I can, for the committee's consideration, agree with the member that the kinds of circumstances where statelessness may arise would more likely relate to a birth abroad where the country does not have citizenship by birth on soil, which tends to be less common outside of North America to begin with. It's not, it may be where the Canadian parent is already first generation born abroad and therefore not able to transmit automatic citizenship, where the other parent, due to any number of circumstances, could include the kinds of circumstances the member has described, is also not able to transmit a citizenship to the child. And furthermore, none of the grandparents on either side are having a citizenship to transmit to that child. And so this is why the cases of statelessness tend to be more exceptional. And there are some, but they tend to be more exceptional. It's not an issue of, just to be clear, statelessness is not really an issue of, well, I have access to a citizenship, but I'm not, don't really want to apply for it, because you wouldn't necessarily be considered stateless in that situation. It's a situation where, in the circumstance I've described, the child does not have access to citizenship through descent or through birth on soil.
So in this case, statelessness truly means you don't even have the right to apply for citizenship from another state. It means do you have to prove that to the department?
Yes, the member is correct in the sense that the grant, this 5-5 grant, one of the criteria is that the person must be stateless, because that's who the safety valve is available for. And so some evidence has to be provided. But ultimately, if the parent is the first generation born abroad, that's not difficult to demonstrate. If the other parent comes from a community where it's known internationally that those populations are stateless, in any event, there is a requirement to demonstrate that. And there are different types of proof that could be accepted.
You mentioned our international commitments on persons who experience statelessness. Is the definition of statelessness used in the Citizenship Act, is it in any way related to the one used in an additional protocol for the Safe Third Countries Agreement, or are they using two different versions of statelessness? Because I know in the protocol there's an update to it. So I'm just wondering, are they the same or are they different?
Madam Chair, they're similar. They're similar, but the parameters we're operating under in the Citizenship Act are informed by the Statelessness Convention that Canada is a signatory, and there are two. It's just off the top. I'm not able to quote the correct year of which one it is.
And so this will just be my last question on this. You mentioned these treaty obligations, and it's hard to tell whether this would be compliant with our obligations. Can you mention what are our international obligations? Like, what are the treaties or commitments we've made to other countries, if you have those offhand? And kind of related to that, is it possible for the department to provide us, like, if we don't, I hope this passes, because I think it's reasonable. It's a very, very few cases would be affected by it. So, those are usually the best, types of examples. But could we get maybe the department to, give us some analysis on whether this would be compliant? Because if we produce more amendments on a table on the floor that are similar in nature, I'd like to be assured that we don't pass legislation with a clause that could be found in contravention, and then a court will rule that this contravenes it and just knocks it down. That would take litigation for someone to prove it. And in these particular cases, it would likely be someone who doesn't really have the means to do it, so they'd need to get a pro bono lawyer or a foundation to take it on. So, is it possible for the department to provide that type of quick analysis, whether this would be compliant with our treaty obligations for a future meeting, not necessarily this meeting, in case of future amendments, which are in the same vein and the same content principle, let's say.
Madam Chair, my colleague has helpfully reminded me that it's the 1961 Convention on the Reduction of Statelessness. And in response to the first part of the member's question, I mean, generally the obligation that we have and that we take very seriously is not to render our own citizens stateless, hence the 5-5 grant and safety valve available to a stateless child of a Canadian, as we discussed. With regard to any analysis, I really can't say at this time, Madam Chair, how long that may take. And I am mindful that we have been reminded on a few occasions that there are some time considerations for the committee's consideration of this particular Lost Canadians bill. Thank you.
Yeah, just to that point, you mentioned this is Statelessness Conference of 1961. Just for my information, how many other conferences on statelessness have we had since then? Are these an annual event or a decade event? Or
Sorry, Madam Chair. I was referring to the 1961 Convention on Statelessness. It's not so much a conference, but an international legal instrument. Thank you.
Yes, convention is the word I meant, because that's what you used. My apologies.
Tired, Larry.
So have they had other conventions since then?
Madam Chair, there is one other that I'm aware of, but I forget the year for that one. Oh, my colleague here tells me it's the 1954 convention, but Canada is not a signatory to that one, as far as I'm aware. Thank you.
Yeah. So. I was pretty sure that might have been since 1961, but it was 1954. So thank you very much for that. So we've had 62 years without another convention on that particular topic. So it's very relevant that we can follow the guidelines from the 61 convention and deal with that in our own legislation here. Are there any other, that we've got some of the situations and listed under F here, charged with, trial for, convicted, those types of areas. Is there any other area there that you think we could have included in this amendment?
Madam Chair, I'm not aware of any at this time, but as we've only just had this amendment tabled during the session, we haven't had that opportunity of a more étude approfondie or a deeper study. Thank you.
Yeah, no, that's all I had.
Mitch?
Just very quickly, Madam Chair, just wanted to give a notice of motion. It is a notice of motion, verbally, and here it is, and I'll give it to the clerk afterwards, that the committee report the following to the House, that international students who are victims of fraudulent admission letters deserve to be heard, and their testimony is of critical importance to a future investigation by this committee, and therefore stays of deportation must be issued for the victims of this fraud until the committee can hear their testimony.
Okay. Thank you. Seeing no seeing no further debate, we will go for a vote on the amendment move. Ms. LaRoche, you want to say something?
Non, je veux simplement m'assurer qu'on puisse faire circuler.
I simply wanted to make sure that the amendment could be circulated. A notice of motion. Okay, we'll get it anyway. You'll
put it on notice. It will be circulated. Ms. Rampel-Gardner?
Thank you. I just have one more quick comment to Madame LaRouche, who I'm very glad to see at our committee.
You didn't see me before.
No, I did. That was nice. I just also wanted to reemphasize the comments of the department. My understanding is that the scope that this would apply to is very narrow. So it would not, and I understand her question that it was, would it apply to broader pieces of legislation? It would not. And just to give her an example of the fact that we have already qualified some of the other parts of the bill or other parts of the provisions in this bill with things like called a substantive presence test. So there are rules in place so that it wouldn't just, that there are rules in which it would apply to, but it would be very narrow in scope. So I just wanted to make sure that her concerns were taken care of prior to the vote being taken here.
Thank you. Seeing no further debate on this, we will go for a vote. We are voting on the amendment moved by Mr. Reddycop. Mr. Clerk, if you can please take the vote.
Mr. Ali?
No.
Mr. Dhaliwal?
No.
Mr. El Khoury? Madame Kayabaga?
Nay.
Madame Lalonde?
No.
Mr. Kmitch?
En faveur.
Mr. McGuire?
For.
Mr. Reddycop? Ms. Rempel-Garner?
Yes.
Madame Larouche?
Pour.
Ms. Kwan?
No.
Yeas 6, nays 5. Pardon me. Yeas 5, nays 6.
Okay. The amendment is defeated. We will now proceed to G6. Ms. Lalonde, would you like to move G6? Ms. Lalonde.
Yes, sorry about that.
Ms. Lalonde, would you like to move G6?
No.
No? Okay. So next is NDP 11. Just to remind everyone, NDP 2 was defeated. It makes a reference to paragraph 3(1)(s) that would have been created by NDP 2 had it been adopted. So this. Next, we have NDP 10, just to let everyone know that NDP 2 was defeated, and it makes a reference to paragraph 3(1)(s) that would have been created by NDP 2 had it been adopted. So we cannot move that. And then next is NDP 11, and that also, as NDP 2 was defeated, it makes a reference to paragraph 3(1)(s) that would have been created by NDP 2 had it been adopted. So next, we will go to NDP 12. Ms. Kwan, would you like to move it?
Yes, thank you very much, Madam Chair. I have a new NDP 12 that has been provided and circulated to all the members. Effectively, the NDP 12 amendment that I am moving provides for an exemption to the automatic conferring of citizenship for those who don't want it, and includes a mechanism for people who will be able to provide written notice to the minister that they are exempt from the application of the new provisions of the Act under which they would otherwise be citizens. And so, Madam Chair, we had some discussion during committee with witnesses, and then also I think officials' concerns to say, how do we ensure that people who actually don't want this automatically conferred to them be addressed? And I believe that the amendments that I've tabled actually addresses that.
Thank you, Ms. Kwan. This is, just to remind everyone, this is new NDP 12, which was circulated to all the members. New NDP 12, reference 12456801. Okay. 12456801, new NDP 12. Mr. Reddycop.
Thank you, Madam Chair. I guess to start out with, to the officials, give us your thoughts on this amendment.
Thank you. Thank you, Madam Chair. This is a necessary provision and safety valve to address the circumstances of those who this bill would automatically make citizens. and for whatever legal, professional, or personal reasons it may be problematic. And so the proposed provision is crafted in such a way that it would, on the persons notifying the minister and the department and fulfilling these limited conditions, i.e. they have another citizenship and they don't reside in Canada, would be deemed never to have been made automatically Canadian citizens. And the reason that that's desirable is, as we spoke about some committee hearings ago, it's difficult to know ahead of time how the automatic citizenship provisions in this bill and these amendments may interact with other countries' laws. And so this proposal is the most effective way of addressing that concern by deeming someone never to have been a citizen. It leaves no room for interpretation. We would suggest by another jurisdiction. Thank you.
Thanks. Okay, so just a little confused. So the reason for this is because of prior amendments that we've made, or is the reason for this related to the way the Citizenship Act is currently written?
Madam Chair, even if the bill had not been amended, a provision like this is helpful even with regard to the Section 8 persons who are being remedied by the bill, as was proposed by the bill sponsor, because there could be circumstances in which some of those people who never came forward for the original remedy may need to find themselves in situations where they don't wish to be a Canadian citizen automatically. It may cause them professional, legal, or other challenges. And so this amendment is helpful for the original scope of the bill as well as the subsequent amendments.
Thank you, Mr. Redigal. So, okay, so that's helpful. So what you're saying, Ms. Girard, is that with the original, we had this talk about the original track we were on where we were going to have this passed quickly, and the new track we're on that adds all the complexity to the bill. So what you're saying is that the original changes that were proposed by the Senator and then were modified, the wording that was modified according to the department, which was agreed upon, would have still needed a clause like this to protect it from unintended consequences, or to give people the ability to opt out of citizenship. Is that what you're saying? So even if we hadn't made all the other amendments that we had related to adoption and other ones, we would still need this amendment in order to make sure that the original intent of what the Senator had proposed would work properly?
Madam Chair, some safety valve is always necessary whenever citizenship is being accorded automatically and retroactively, and that was the case with the previous legislative amendments. So I would say that's the general answer to the member's question. What my recollection is that in the discussion with this committee, there was particular consideration to those benefiting from the connection test, and so a mechanism like this will also be available in those cases. Thank you.
Thanks. So in terms of numbers, have there been, I guess right now, what does a person do if they can they get in this situation with the law the way it is currently written, with the Act the way it's written? Can they get in a situation where they need to not have Canadian citizenship? Is that a situation today?
Yes, that's correct. Currently, someone has to apply to renounce their citizenship.
And what are some of the circumstances you've run across that people would want to renounce their citizenship?
Madam Chair, they may vary, but one of the circumstances we're aware of and that I mentioned previously was one where someone may be working abroad in a profession where they may not be permitted to hold another citizenship, whether they're a legislator, another holder of high office. It's not uniquely those circumstances, but that is one example that has been discussed in the media on a number of occasions in recent years.
Thanks. Okay, and so then, I guess how many cases like this occur in the departments in your experience?
Madam Chair, I do not have those statistics in front of me, but we do have them, and I believe we were to provide them to the committee. We may have done so recently, or maybe close to doing so. And so, certainly, if we've not recently provided them, then we will follow up and ensure that that's done.
Yeah, that would be good. It would be very good to know kind of the scope. And then I guess with this clause then, oh, wait a minute. Do I see a late answer coming in?
Madam Chair, with your permission, we, in response to the member's question, because I didn't have it in my own binder, but a colleague has passed it. So, between 2018 and 2002, the department processed a total of 1,362 applications to renounce Canadian citizenship. And so between the years of 2018 and 2022, I see between 99 and 393 such renunciation applications processed. So there's a bit of a range there, but it gives at least the order of magnitude. Thank you.
Sorry, there's a bit of noise. So just clarify. So between 2018 and 2022, you said there was a range of 99 to 303. Is that what you said?
Yes. So 1,362 applications to renounce citizenship processed in total. That's decisions. And in any one of those 5 years, a range of between 99 renunciation applications processed in 2020 as compared to 393 applications processed in 2022.
Any idea, Ms. Girard, as to why all of a sudden it went up so much in 2022? Was that potentially carry over from COVID issues, or any idea?
Madam Chair, we don't have any information to that effect, and it may vary depending on individual circumstances, desire to come forward and pursue an application, and so on and so forth. Thank you.
So, if these changes are enacted as they are. What's your feeling as to where those numbers will go? Are they going to be higher, or is it going to be more or less the same kind of numbers? What's the department's view on that?
It's not possible to estimate with any certainty, but the numbers are that I've quoted for those 5 years are not very significant by any stretch, and so it's reasonable to anticipate that we may have less or similar volumes, and that the volumes would remain in the hundreds per year. That would not be an unreasonable assumption.
So with the 1,362, was that approval? Like was that acceptances, or was that requests to?
So that was total processed, and of that number, 1,362 applications to renounce processed. 1,262 were approved, 9 were refused and 91 were withdrawn. And my colleague confirms to me that these are statistics that we've recently shared with the committee.
Thank you. That's very interesting. So, what would be the reason for refusal? I'm struggling to understand that.
Madam Chair, the renunciation applications are covered under Section 9 of the Citizenship Act. And the first thing is that someone who wishes to renounce their citizenship has to be a citizen of another country, or if their application is accepted by Canada or in the Immigration our department, they will become a citizen of a country other than Canada. And, that's in line with our obligations not to make our own citizens stateless, to sort of rejoin our previous conversation. They have to not be a minor, not be prevented from understanding the significance of renouncing their citizenship by reason of a disability. And they also have to not be residing in Canada. So those would be reasons for refusal. If someone was residing in Canada, we wouldn't be in a position to accept the application, for example. Or if the person didn't hold another citizenship, we wouldn't be in a position to accept.
Can you just explain again the disability one? I didn't quite understand that one.
Under the legislation, it reads under 9(1)D, is not prevented from understanding the significance of renouncing citizenship by reason of the person having a mental disability.
Okay, yeah, that makes sense. So would it be fair to say that of the withdrawn applications, typically they maybe didn't understand those rules you just mentioned, and the person withdraws that, or are there other reasons why people would withdraw their applications?
Madam Chair, I believe that's probably a fair understanding or assumption. I do not have any detailed breakdown as to why applications may have been withdrawn.
I think I might be done for now.
Yes, you have some questions?
Oh, yes.
Okay, so we will have to stop here because we don't have the services like beyond 8 o'clock. We have a time slot available for 11 to 1 tomorrow, and I am requesting that we have the meeting for a bill S245. So I have checked, and the resources are available. We can get that time slot, so I will request for the meeting to be called. So details will be sent out to you in regards to room number and everything. So we will have the meeting tomorrow from 11 a.m. to 1 p.m. Details will be sent out. It will be on bill S245, clause by clause. Ms. Rempel-Garner.
Yes, Chair. A point of order. Since this meeting is going to occur tomorrow, it behooves me to point out that it is my colleague, Mr. McGuire's birthday tomorrow. So I would just ask that perhaps we sing him happy birthday tomorrow during the meeting, or give him a slice of cake, or Mr. Al-Khouri's famous baklava with a candle in it. Thank you.
We can get a cake. Yes. We can. I will get a cake. It was my birthday on last Friday also, so we were not here. Yes, it was May 26th. Yeah. Oh.
So wait till next week.
So just to give an incentive, we will have a cake also tomorrow. 11 to 1, we will have the meeting, and now the meeting is adjourned.